As you understand, there is a second amended motion to revoke unadjudicated probation motion filed January of this year. So we've gone through about a half a year
Mhm.
and we need to move forward one way or the other. What are we going to do on this, David?
Miss Stout has some problems.
Stout, Sylvester.
Excuse me, Sylvester. I apologize to Miss
That's fine.
Sylvester. Miss Stout also, but she had some problems. I've spoken to her on more than one occasion. These started, I believe, in early January, February, something like that. Miss Sylvester denied that she pled guilty before the court on the original case here. Basically, as we went through the motion to revoke probation, she denied committing any of them and wanted to talk to the court about whether she committed any of these offenses because she didn't think that she should be here. She has not violated her probation, I guess is what I think she is stating.
Correct. I have not violated it. I have made every.
No, you've never been on probation? Or
I've
you
been
are
on probation now since 2022
Right.
of December.
Yeah, that's not what you just said, David.
I've never been in any trouble or anything like that.
No, here's what's been alleged is you failed to report to the probation office in June of 23, August of 23, and September of 23.
Mhm.
You failed to work faithfully at suitable employment and provide verification of such. That's what it alleges. I know what happens with a lot of folks. As long as you're trying hard to get employment, that's what's important to me. You failed to provide verification of performing community service hours as required, and that's important because that's community service and that's a necessary concept of probation. You failed to provide verification of entering and successfully completing an anger management program as directed by the probation office. That's important when there are certain cases like assaults. Everybody has to go through that. It's a short program, but it's very good and helpful. Then there's failing to pay court assessed fees as directed. This says you were $734 in arrears in court fees as of January. But some people can't pay. And if you can't pay, you don't go to jail on my watch.
Well,
And
I
hold on,
have the
one more.
ability.
And this says you failed to report to the probation office on or about September 14th, 2024 for a judicial review.
Statement moved to amend that date to September 13th, Judge.
I was not aware that I needed to go back to the probation office based on what I was told over the.
Okay, wait, hold on.
Over the.
That's for me to decide and a
Okay.
hearing. I mean, you're going to plead untrue to it is what we're saying, what you're saying. I'm not going to change it. It says on or about September 14th.
All right.
It's
Well,
good enough for me.
what I
Okay.
would like to add is that I've made every effort to keep the check-in dates with my probation
Okay, that's
officer, excuse me, several times. I then was
Hold on.
rescheduled.
Hold on. Here's what we're going to do. If you're pleading untrue to all of these, then we have a hearing in front of me. That's me to decide. I get to hear both sides and then I make the decision. That's the way it works.
Well, what I would like is for the probation to be reinstated.
Okay, I understand what you like.
Okay.
I'll listen to that at the end of the hearing.
Okay, so that's not something that can be done today.
We can do the hearing today if you want. These are all
That's
what I just told you.
That is what I would
You need
like
to prepare for this.
to
I
be
think that
reinstated. That way I can be on my way because I've got a special needs child to take care of. I've got a family
Who's
and
taking
I've
care of the
got
child now?
a gospel singing career as well.
Who's taking care of the child now?
Me.
No, but when you're in jail, I mean, the child's not with you. Who's taking care of the child when you're stuck?
Well, my child is in a safety place. He's in a safe place, so I can't.
A family?
Yes, he's with a close family member.
All right.
So he is
Well, it
safe.
needs
He's
some money.
with me. However, yes,
Is that what you're trying to say?
that is what I'm saying.
All right, what do we want to do today?
Judge, I believe that what Ms. Sylvester wanted to do today was to have these addressed by the court.
Well, we have to go through a hearing and enter
Well,
pleas.
yes, sir.
Is that
Yes,
what
sir.
we're
And
gonna
I
do?
think that's what the court, why the court
Is
said
that what
it.
we're gonna do?
Hearing.
Yes, sir.
All
It's
right,
a
raise your
hearing, I
right
believe.
hand, ma'am. Raise your
I'm
right
sorry.
hand.
Okay,
Do you solemnly swear or affirm any statements you may make during this hearing will be the truth, the whole truth, and nothing but the truth? So help you God.
yes.
All right, lower your hand.
Okay.
Does the defendant waive a formal reading of the second amended motion to revoke unadjudicated probation? Can we proceed in a summary fashion to move this along?
Yes, your honor.
In summary, ma'am, this states that on December 19th, 2022, in this court, I placed you on deferred or unadjudicated probation for 10 years for the third-degree felony of assault on a public servant. Is all of that true? Is all of that
Could
true?
you read me the date again? You said.
December
2019?
19th, 2022. You were placed on 10 years deferred or unadjudicated probation.
Well, correct.
Is that correct? All right, that's
That
what
is
it
true.
shows in all this file.
Correct.
Allegation number 1 states you failed to report to the Jefferson County Probation Office on or about June 18th, 2023, August 14th, 2023. Now we're going back 2 years. September 6th, 23, in violation of your probation order. Is that true or untrue?
That is untrue.
Okay, that's all you need to say. We're gonna hear both sides on that. This states number 2, you failed to work faithfully at suitable employment and provide verification of that in violation of your probation order. Is that true or untrue?
That is untrue.
Okay,
I
that's
did-
all. No, you're gonna get to explain that. We just need to figure out what's true, what's not first. 3, you failed to provide verification of performing community service hours as required of your probation order. Is that true or untrue?
That is untrue.
Four.
That one is true because so yes,
Okay, you'll be able to explain all of that later.
that one is a
4,
yes.
you failed to provide verification of entering and successfully completing the anger management program as directed by the probation office. Is that true or untrue?
I did not provide verification of entering it, but I did show up to class.
It's
So
no.
a yes and no on that one because
It's entering
technically,
and successfully
Okay,
completing.
then
It's
no.
conjunctive. You have to do both parts.
then no.
All right. I'm not gonna go on this. You're paying as much as you can pay toward all of these costs and everything, aren't you?
I'm paying the count 5, Judge.
Yeah, I don't even want to go into the money. 6, you failed to report to the probation office on or about September 14th, 2024 for a judicial review. Is that true or untrue?
That is untrue
All right,
because I wasn't
that's all we
given the
need.
information.
Yep, that's all we need to know. Okay, go ahead, state.
I
You're ready to
recall-
proceed today, right?
I'm ready,
everybody?
Judge.
All right. No objections. Go ahead, state.
I would call Dominique Mayfield.
Raise your right hand, ma'am. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Lower your hand. Go.
State your name for the record,
Dominique Mayfield.
and what do you do for a living, ma'am?
I'm a probation officer here in Jefferson County.
How long have you worked for Jefferson County?
About a year and a half now.
And in that capacity, did you come to know Brittany Sylvester?
Yes.
And when was she, in what capacity? Was she placed on your caseload?
Yes.
When was that?
February 14th of 2024.
Okay. So prior to that date, do you have access to her file as far as who she was assigned to before that?
Yes.
And that's a part of the records that you get whenever you inherit a caseload, is that right?
Yes.
So who was the prior officer before February 14th, 2024?
Please, ma'am.
It was Helena Hilliard. She was
683.
All right, so let's start with, do you see Miss Brittany Sylvester in the courtroom?
Yes.
And you go ahead and just identify for me what she's wearing so we can get that clear for the record.
Yeah, she's wearing a blue jumpsuit.
And may the record reflect she's identified Miss Sylvester.
Yes, it would.
And is it true that she was placed on probation back on December 19th of 2022 for assault on a public servant?
Yes.
And all my questions are going to be about that, okay?
Mhm.
Let's work backwards. I want to start with the judicial review. When was that scheduled that's alleged in count 6? When was that?
Originally, it was supposed to be back in May of 2024, I want to say.
Okay,
And then afterwards, it kept being reset. So once we got that updated information, we relayed that information to her, putting it to the last known phone number that we had on file. And when we came to court, she did not show.
all right. Was that on or about September 14th of 2024?
Yes,
That judicial review?
yes.
So what were we trying to take care of with these reviews that were scheduled and rescheduled? What were we dealing with as far as this lady is concerned?
Originally from counts 1 through 5, well, 1 through 4,
Yes, sir.
she was given time to get started on community service, find employment, and do all the conditions of her probation. And then after that, we were gonna come back to see her progress.
All right, so I'm looking at a memorandum that's dated in July of 2024, and it says that on February 14th, that she was placed on the mental health initiative caseload.
Yes,
Is that true?
yes,
Is that your caseload?
yes,
That sounds like the date you told me that you've been her officer.
yes.
So prior to that date, your access to her, but you've been dealing with her specifically from that time frame. Has she reported to you anywhere in there?
Yes.
When?
Her last office date report was May the 28th of 2024.
Year ago? Over a year ago?
And at that
Is that
date,
right, everybody?
yes, sir.
Over a year ago?
So the judge typically wants to know if someone's at absconder status. Is that what her status was?
She became an absconder in it was August the 30th of 2024.
So I know and you know, but let's make the record clear. So that means from May 28th up until August 30th, she didn't report at any point in time in there, did she?
No,
Did she give you, did you have any contact with her to indicate why? But other than her just missing scheduled timeframes, did she tell you why?
yes, after a while, she would fail to report and then she'll call and get the appointment rescheduled. And then on a rescheduled date, she didn't show.
And all those communications were directly with you, right?
Yes,
All a part of that mental health initiative caseload.
yes,
In that time frame, did she work at work at employment, trying to maintain employment?
not to my knowledge.
And she would have been reporting that to you as conditions if that was true, right?
Yes.
What about her attempting to do community service hours?
She received 2 different forms. One was for the nutrition center, but she was unable to complete community service there. So I had her sign a new one to come to the courthouse and complete community service. And I gave her a copy of it. I have a copy right here where she signed it. And still no community service or anything was completed.
So what we're looking at that you just handed me is a form that's got her signature and it's dated April 4th of 24.
Yes,
And that's you giving her information about where she can go. It's actually entitled the CSR referral form, right?
yes.
What does CSR stand for?
Community service restitution.
In this manner where you tell individuals about where they can go and get their stuff done, is that normally what we do there at the department?
Yes,
And to your knowledge, after giving her this information, did she go on and do any of that?
no,
Do you have any records indicating that she's completed any community service since she's been on this probation?
no, she hasn't completed anything.
Not one hour?
No, sir.
2.5 years? In 2.5 years, not 1 hour?
Tender, State's Exhibit 2, the purported CSR referral form from April 4th of 2024.
I was denied when I showed up to the nutrition center. Oh, okay, okay,
Wait on that.
because I did show up and
Then
everything.
Mr. Ham.
Do you have any objections?
I have no objections to this time with cross-examination.
All right, so just
So
to be clear,
there were no objections. What is that?
State's Exhibit 2, it's the CSR referral form. And to be clear, this is her signature at the bottom with the date, correct?
Yes.
States Exhibit 2 is tendered into evidence without objection.
That's correct.
All right, so
Admitted. Go ahead.
what, if anything, did she do towards the anger management program?
Originally we sent people through family services, but because she was not working, we have another option, which is through Faith Tabernacle. They do the 12 sessions, it's free of charge. And if they do not have transportation, they also provide it.
Did she go?
No.
So as far as your time frame working with her, you gave her a free option and she didn't exercise it.
This is
Right.
allegation number 3.
That's allegation number 4. She's pled true to allegation 3, which I supported with State's Exhibit 2.
And then this is 4 is the anger management program
Yes, sir.
through what entity?
What was the entity?
Faith Tabernacle. It's in Port Arthur.
Okay.
So the dates that are alleged in count 1 about her non-reporting, we've already covered. She hasn't reported to you since May 28th of 2024. What do your records indicate about her reporting to Jefferson County on June 18th, August 14th, and September 6th of 2023? Those predate your time, man. What does it show?
At that time, she was assigned to Miss Valier, and I want to say she did not report on those days, and then later on she was arrested, and Miss Valier met with her in the county jail. Then afterwards, that's when she was placed with me.
All right. So the non-reporting that we deal with in count 1, the department addressed that it was true by giving her a chance to work with you in your program.
Correct.
So now that you're here and having a chance to visit with the judge, in your opinion, has she done well trying to adjust to this caseload that you're assigned?
Yes, she would, like I stated, she would call and ask to reschedule, but those dates that she would be rescheduled for, she didn't attend.
Wow.
So out of the times,
Ma'am, you know what? Don't be rude. She
No,
gets to
please.
speak. Yes, you were.
I'm not trying to.
You
be rude,
just
Judge.
be quiet. You
Okay,
get a
I
chance
am.
to, just don't make comments when the lady is speaking, please. Thank you. And we won't interrupt you and be rude.
Okay, thank you. I didn't mean
If
to.
rude was
I
a
do
condition of
apologize.
probation, you'd be revoked for that.
I pass the witness, Judge.
Go ahead.
Now, basically, let's go back to 2023. It sounds like she didn't report back at that time. I mean, before you were actually there, but that's what the records would indicate.
Yes.
Is that right? And this wasn't dealing with you, it's dealing with your predecessor. But she didn't report back then, right?
Correct.
All right. And what efforts were made to help her get some assistance in being able to report, I guess?
At that time, when I was working with her, she did inform me that she was homeless. As far as that, on my end, I try to give resources of different places that you can go if it need be for like clothing, food, and different things like that. I do give out resources. But that's all I'm able to do.
Okay. You said that she wasn't trying to work during the time when you the earlier part of the time you were employed at probation. Was she employed during that time, as far as you know?
No.
Did she work as a preacher?
She did tell me she was a prophet, but as far as like showing any verification of anything, I've never received it.
Yeah. But she told you she was working as a preacher. Is that basically what she said? Is that how you?
Yeah, that's just
No.
like,
Okay.
And everything needs to be verified. Everything needs to be verified
Judge,
for every probationer.
I hate, if I may, I want to interrupt counsel for just 1 second. My notes do indicate that the court held a hearing as to that count 1 back on December 18th of 2023. And after a plea of true, that's when she was kept on probation and moved to the mental health caseload. So I know she's entered a plea of not true today to that same deal, but I think that's been disposed of by the movement to the mental health caseload. Your file may reflect that. If it does,
All right.
then,
It does. She entered a plea of truth to allegation 1 back on
I did
12,
not.
hold on, 12/18/23.
so perhaps we should focus on counts 2, 4.
It's already been found true. Go ahead, go to the next one.
Well, did not represent Mr.
I know you didn't.
Back at that
Go to the
time,
next.
so I'm a little bit behind as far as that
Okay.
goes. But,
Two.
Confirmed that I was working at Wendy's while I was on
Okay.
probation in 2023.
let me ask you that question and you answer the question, okay?
Okay.
All right, now then, let's wait until it's time for you to discuss it.
Okay.
So we could go ahead and ask
Go ahead.
as the present witness. Judge, I'll do this however you want me to. I just.
Move forward. Just move
All right.
forward.
Well,
We're bogging down.
Miss Sylvester, were you working back at that time in 2023?
In 2023, I was working at Wendy's as well as I was working at Steak and Shake. So I had 2 jobs at one time. And my probation officer at that time was Mr. Moody, who did come inside of Wendy's and witness me physically working there. And he just happened to come by, is what he said. He wanted to see if I was working, and that is what happened. Unfortunately, I only had that job for a few months due to me being harassed by one of the management there that was trying to force me into prostitution. So it was no longer safe for me to keep that actual job. However, I did make other efforts to find suitable work, but while I was looking for other jobs such as at Subway, that was another place that I was looking for work at. I was catering is what I was doing, so I would go out with my non-tuna meals and try to sell those
Did you
for
know that?
lunch.
It doesn't do any good if the probation office is not aware of that.
Was this before?
You can't do it you're not on your own probation. You're supervised. We can't supervise you if you're doing things out there that you're not telling the people what you're doing. You
I
don't
did
get credit for it. You
update.
can talk all day long about it. I'm not going to give you credit unless they know, and they supervise you. You don't supervise yourself on probation. They supervise you. And there's no supervision when you're doing things on your own and not telling them. You don't get credit for it. You're going to waste your time. And you don't get credit. David, go to the next one. She sounds like she's trying to work. Go ahead.
Well, can I just make one quick point and move on? Was this before Ms. Mayfield started working there and supervising you, that you went out, we're talking about trying to get these jobs and selling your non-tuna meals? Was that before she was there, or is that after she had come to work for probation?
I don't know if she were physically working there, but that was prior to her becoming my probation
Okay,
person that I was supposed to check in with.
Who was your
Excuse me,
probation?
Who
was the officer?
Officer that I was supposed to be checking in with. Prior to her was Miss Valier. And so she was also aware that I had been working. However, I was doing catering, and I did let her know that I was doing my non-tuna meals that I was going out to sell. And also I told her that I was still looking for other means of work. However, that was what I was doing, as well as being a pastor. And there are several voicemails that I left on the voicemail, keeping them updated about things that I was doing. And also when I
Move on to some
rescheduled.
level. I'm not upset with the employment. Go ahead.
okay, well, you tried to get employment then back at that time.
Marva Carthon was your probation officer?
Who?
Marva Carthon?
Miss Value.
Miss Hawthorne, but there is somebody there, last name of with the last name, Valier. There's somebody there with that last name as well. I think I had at least 3 different probation officers that I am aware of.
Okay.
Miss Mayfield is the 3rd one. I wasn't giving any notice. I just figured maybe people quit. So I may have misspoke as far as the name.
What about the
However, Miss Hart
anger management
Hawthorne
program?
is one of the people that was a
Focus-
probation officer
focus on
of
me.
mine.
Focus on me.
Anger
Oh, no,
Anger
management.
management.
Did you go to the anger management program?
I
That's-
went and they didn't show up.
Who did
Nobody
you-
showed up for the class that I was signed up for at Family Services. It was in 2023. I spoke with Crystal, who was the attendant working at Family Services at one of their off-site campuses where they do offer anger management. I asked her what was going on as far as why no one showed up. She said she didn't know. She was gonna call them and find out why they didn't show up to the actual
All right,
class, but
let me ask you
I
that.
was already signed up for
Anger
the anger
management.
management course,
All right,
and I
stop,
did show up.
stop. Anger management program. What does that consist of exactly? I order it in every case almost, but I've never been to see what it's like. Is it a time program or is it a one thing?
It's well, if you're doing it through Family Services, it's sessions, and you have to pay per session. Then you have the option to do it through Court Solutions online, and it's a 12-hour course. It's self-paced. You pay a one-time fee, and then once you complete it, you print off the certificate and they bring it in.
Okay. How many times do the probationers have to go to a class?
For anger management, they're going in person. It is once a week.
For how long?
12 weeks.
12 weeks. 12 weeks. 12 times. You got to go 12 times.
And they normally.
Did you do that?
So.
No,
I
not even
showed up
close.
once, and they were supposed to update me about
You-
when they
you-
were gonna
ma'am,
come back.
Let me just tell you this. You have everything to lose. We have 5,000 probationers. You've got to do your part you had an obligation, you sign it. This is what I plan to do. This is my promises I make. And you can't rely on them. You've got to do your own heavy lifting and figure it out. And don't blame it on nobody told me. You've got to take a positive effort. It's
Right,
your life. It's your freedom.
right. So that's
We
where
got 5,000 probationers we're working with. But we can't be, this isn't first grade. You're an adult. You've got to do some of the heavy lifting on your own. You have an order of this court that you have to perform. You can't blame it on the fact that nobody told you how to do it. You've got to go seek it out.
Right.
Okay,
So that's
then
what
what's this?
to do.
Family to report September 14th, 2024 for a judicial review.
That was for here.
For here.
Mhm.
Oh, yes, she didn't come to court.
No, she didn't.
Now, explain that one away. If you can.
I wasn't aware that I was supposed to be in court.
Yes, you were.
Because I was told last year when I spoke to Judge Stevens Court that my charges were already dropped. They looked in.
Nobody said that.
Into my name, and that is what I was.
Nobody
told.
said that
They
with my
pulled up
court.
the
They
cause
don't,
number.
they don't do that. That's not
Yeah.
what they do.
Well, they are paid to give me the information since I was representing myself at that time as pro se. And so they were giving me.
You know what they
the
say about people who
the
represent
information
themselves? You
that
know
I
what they
was
say
asking
about,
for.
you're a smart lady. You know what they say about people who represent themselves who aren't lawyers? You have a fool for a client. That's an old saying from way back. That's a foolish choice. You're not competent to do this. You didn't go to law school. Not that you're not capable, you probably are. But you don't have the qualifications, the experience, the training. It takes more than just wanting to do it. It'd be like me doing hair coloring. I wouldn't know what to do. I'd have to learn it. I mean, I don't know. But this, I have 4 degrees, and that's what it takes to be a lawyer. You think I just dreamed that up one day and then I can start representing myself? I can, but there's that old saying, if you want to represent yourself, you have a fool for a client. Because it takes, especially if you're not trained in it and you don't have the law degree and you don't have the bar license, all of that is important to handling other people's lives, including yourself. This is freedom. This is part of the Constitution. You don't want to lose that because you think you can handle something. Brain surgery. Do you do much of that? No. And I'm not being
No,
facetious
very,
about it, but I'm not
smart.
being facetious.
I'm
It takes
actually a
years
genius.
of training. Yeah. Don't interrupt me when I speak. Stop. It takes
You were
years.
asking me a
Wait,
question.
wait,
is what
Do
I
you want to
said.
interrupt me
Okay.
again, ma'am? Ma'am,
Then you can.
Okay.
ma'am, is this that hard? When I speak, everybody's got to stop. That's kind of the rule because she can't take two people speaking over each other. Okay? And next time it happens, you're in contempt of court, which means you go to jail for a longer period of time. You've been
Well,
warned.
It
You
kinda
wanna
seems
speak
like
over me
that's kinda
again?
What you wanna do is what it kinda seems
Ma'am?
like. This is
Don't
my
talk.
first
Ma'am?
time being-
Listen for it.
Ma'am?
Let me finish this.
Ma'am,
Okay.
you're in timeout. We're gonna treat you like the child you're acting like. You're in timeout. I'll deal with this next week. Okay? I'll deal with this next week. I've had enough of your rudeness and you're speaking over everybody. Just like that. You're going to go to jail. I'll deal with this next week.
Okay.
Bye.
This is my first time
That's
ever being.
No, it's not, ma'am.
Yes, it is.
You-
I've never been in
Ma'am,
trouble.
you're an adult.
Why are you pulling my?
Ma'am, you're under arrest. That's why. You're in custody.
I understand that.
All right, thank you. Quit being rude. Quit being rude, ma'am. Thank you. You're rude. Quit being rude.
What we just witnessed wasn't just a probation hearing, it was a masterclass in how probation can unravel when communication, compliance, and courtroom conduct break down all at once. Let's break this down carefully and professionally. Brittany Sylvester was originally placed on deferred adjudication probation for 10 years after being charged with assault on a public servant. Deferred adjudication is not a conviction yet. It's essentially the court saying, follow these rules and we won't formally convict you. That's a second chance wrapped in strict conditions. But that second chance comes with obligations, report regularly, maintain employment, complete community service, attend anger management, and show up for court. Now here's where things start stacking up. The probation officer testified that Sylvester hadn't reported since May 28, 2024. That's not a small oversight, that's over a year without reporting. In probation terms, that's a major red flag. She was declared an absconder in August 2024. For those who don't know, absconder status means the system believes you've essentially disappeared from supervision. That's serious. Then we have community service. 2.5 years, not one verified hour completed. Even after being given a signed referral form, that's documented evidence presented and admitted without objection. When paperwork with your signature shows you were directed where to go and there's still zero completion, that's incredibly difficult to overcome in court. Next, anger management. The judge clarified something important. It's a 12-session requirement. Whether online or in person, it must be completed and verified. Showing up once or saying the class didn't occur isn't enough. Probation requires proof. Courts operate on documentation, not memory or intention. Now, here's where it gets layered. Sylvester claims she worked at Wendy's and Steak and Shake. She says she was catering meals. She says she was preaching. But the judge makes a key legal point. Probation is supervised. You don't supervise yourself. Even if she was working, if it wasn't verified and reported properly, the court can't credit it. That's not personal, that's procedural. The judge also revealed something critical. She had previously pled true to at least one violation in 2023 and was moved to a mental health caseload instead of being revoked. That suggests she was already given an opportunity to correct course. When courts give adjustments instead of revocation, that's usually seen as leniency. Then we get to courtroom behavior. This is where the temperature rises. Interruptions. Speaking over the judge. Attempting to argue while rulings are being made. In any courtroom anywhere in the country, that's dangerous territory. Judges maintain authority not for ego, but for order. Once decorum collapses, the court can't function. And when the judge warned her about contempt, that wasn't theatrical, that was procedural. Contempt of court is the power a judge has to maintain control. After repeated interruptions, the judge exercised that authority. Here's the broader takeaway. Probation is freedom with structure. It's not prison, but it's not independence either. It requires initiative, documentation, and humility. Courts manage thousands of probationers. The judge even said it plainly, we have 5,000 probationers. That means systems rely heavily on individuals doing their part. Now let's ask the tough questions. Do you think the system failed her by not following up harder? Or do you think she failed herself by not meeting clear conditions? Should homelessness and hardship factor more heavily into probation flexibility? Or does structure have to remain rigid to keep the system fair? This case shows us something powerful. Effort without documentation doesn't count in court. Intent without compliance doesn't hold up legally, and courtroom decorum matters just as much as legal argument. Professionally speaking, the judge appears to be weighing repeated noncompliance combined with courtroom behavior. Deferred adjudication cases can end in full conviction if revoked. That means the stakes here are enormous. And one final note, the moment she chose to represent herself earlier in the process, the judge's warning wasn't sarcasm. Legal training matters, procedure matters, deadlines matter. Freedom can hinge on paperwork and timing. This wasn't just about missed appointments, it was about credibility, structure, and accountability under supervision. Now we turn it over to you. Was this a system overloaded with too many probationers to truly support someone in crisis, or was this someone repeatedly given chances who refused to follow through? Drop your thoughts in the comments. I want to hear where you stand on this. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. What we just witnessed wasn't just a probation hearing, it was a masterclass in how probation can unravel when communication, compliance, and courtroom conduct break down all at once. Let's break this down carefully and professionally. Brittany Sylvester was originally placed on deferred adjudication probation for 10 years after being charged with assault on a public servant. Deferred adjudication is not a conviction yet. It's essentially the court saying, follow these rules and we won't formally convict you. That's a second chance wrapped in strict conditions. But that second chance comes with obligations: report regularly, maintain employment, complete community service, attend anger management, and show up for court. Now here's where things start stacking up. The probation officer testified that Sylvester hadn't reported since May 28, 2024. That's not a small oversight, that's over a year without reporting. In probation terms, that's a major red flag. She was declared an absconder in August 2024. For those who don't know, absconder status means the system believes you've essentially disappeared from supervision. That's serious. Then we have community service. 2.5 years, not one verified hour completed, even after being given a signed referral form. That's documented evidence presented and admitted without objection. When paperwork with your signature shows you were directed where to go, and there's still zero completion, that's incredibly difficult to overcome in court. Next, anger management. The judge clarified something important. It's a 12-session requirement. Whether online or in person, it must be completed and verified. Showing up once or saying the class didn't occur isn't enough. Probation requires proof. Courts operate on documentation, not memory or intention. Now, here's where it gets layered. Sylvester claims she worked at Wendy's and Steak and Shake. She says she was catering meals. She says she was preaching. But the judge makes a key legal point. Probation is supervised. You don't supervise yourself. Even if she was working, if it wasn't verified and reported properly, the court can't credit it. That's not personal, that's procedural. The judge also revealed something critical. She had previously pled true to at least one violation in 2023 and was moved to a mental health caseload instead of being revoked. That suggests she was already given an opportunity to correct course. When courts give adjustments instead of revocation, that's usually seen as leniency. Then we get to courtroom behavior. This is where the temperature rises. Interruptions, speaking over the judge, attempting to argue while rulings are being made. In any courtroom, anywhere in the country, that's dangerous territory. Judges maintain authority not for ego but for order. Once decorum collapses, the court can't function. And when the judge warned her about contempt, that wasn't theatrical, that was procedural. Contempt of court is the power a judge has to maintain control. After repeated interruptions, the judge exercised that authority. Here's the broader takeaway. Probation is freedom with structure. It's not prison, but it's not independence either. It requires initiative, documentation, and humility. Courts manage thousands of probationers. The judge even said it plainly, we have 5,000 probationers. That means systems rely heavily on individuals doing their part. Now let's ask the tough questions. Do you think the system failed her by not following up harder? Or do you think she failed herself by not meeting clear conditions? Should homelessness and hardship factor more heavily into probation flexibility? Or does structure have to remain rigid to keep the system fair? This case shows us something powerful. Effort without documentation doesn't count in court. Intent without compliance doesn't hold up legally. And courtroom decorum matters just as much as legal argument. Professionally speaking, the judge appears to be weighing repeated noncompliance combined with courtroom behavior. Deferred adjudication cases can end in full conviction if revoked. That means the stakes here are enormous. And one final note, the moment she chose to represent herself earlier in the process, the judge's warning wasn't sarcasm. Legal training matters, procedure matters, deadlines matter, freedom can hinge on paperwork and timing. This wasn't just about missed appointments. It was about credibility, structure, and accountability under supervision. Now we turn it over to you. Was this a system overloaded with too many probationers to truly support someone in crisis, or was this someone repeatedly given chances who refused to follow through? Drop your thoughts in the comments. I want to hear where you stand on this. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.